Hello students, welcome to our polity series. In this class, we will discuss about judiciary system in India. Judiciary system, in this topic, we will discuss about the three types of court in India. One is Supreme Court of India, second is High Court in India, and third is subordinate courts in India. The Supreme Court is the head, last or the powerful court in India which deal with the center, the High Court for states and subordinate court for the districts only. So let's start with the Supreme Court in India, which deal under Article 124 to 147. Under Article 124 to 147, the Supreme Court of India is mentioned. Let's discuss the history of Supreme Court in India. The first Supreme Court of India was established in 1773 during the Regulating Act in Calcutta only. And the first CJI of Supreme Court was Elijah Impey. So when Warren Hastings became the Governor General of Bengal under Regulating Act in 1773, the first Supreme Court was also established in India. The first Court of India was established in 1773 under Regulating Act in Calcutta. But the present Supreme Court, which is in New Delhi, was established on 28th of January 1950 under Article 124. So recently, the Supreme Court of India is in New Delhi, which was established in January 28, 1950, but the first Supreme Court was established in 1773 Regulating Act. When the first Supreme Court was established, there were total 7 plus 1 judges. 7 plus 1 means there are some judges and there is a head which is known as the CJI, Chief Justice of India. So the Supreme Court consists some fixed judges and a head known as CJI of India. So when the Supreme Court was established, that time there was total 7 plus 1 means total 8 judges. But at present there are total 34 judges in the Supreme Court, means 33 plus 1. 33 are the other judges and 1 is the Chief Justice of India. So the question is, who has power, who can increase the number of judges of Supreme Court time by time? The parliament got power that parliament can increase the number of judges time by time in the Supreme Court. So the number from 8 to 34 was increased by the Parliament of India. Clear? Okay. Next, in this session, we will also discuss the qualification, the removal and the appointment of the Supreme Court judges. First, what are the qualifications to become a Supreme Court judge? Any person who is the member of or citizen of India or having at least 5-year experience as a judge of any high court or 10-year experience as a advocate of any high court under Article 124 clause 3. So Article 124 clause 3 explain about the qualification of Supreme Court judges, and it explain that a person must be a citizen of India. He must be a judge of any high court for at least 5 years or Supreme Court or advocate of any high court for at least 10 years. So a person must be follow these qualifications to become a judge of any Supreme Court. Okay, what is the procedure of appointment of Supreme Court judges? The Supreme Court judges can be directly appointed by the President of India but through collegium system. So here we will also have to understand what is collegium system. Let's first understand what is collegium system. Collegium system was introduced in India in 1993. In 1993, the collegium system was introduced in India. Clear? Collegium system is the part of a 5 members team. So there are 5 members consisting 1 Chief Justice of India and other senior judge of Supreme Court. The 1 member is Chief Justice of India and 4 other senior judge of Supreme Court comprise in the collegium system. That's why it is a 5-member judges. So these collegium system are responsible for the appointment of the Supreme Court judge. These 5 members check whether this person is eligible for the Supreme Court judge or not. Then they send their recommendation to the president and finally the judge is appointed by the President of India. The collegium system, it was introduced in 1993. Before 1993, if a judge retired, then he appointed his relatives in place of himself. Okay, In 2014, the collegium system was replaced by the NJAC system, National Judicial Appointment Commission, but laterly NJC system in 2015, again named as the collegium system of India. There is a procedure in which we can remove the judges of the Supreme Court. The judges of the Supreme Court can be directly removed by the president, but there is a procedure under Article 124 Clause 4. So Article 124 Clause 4 explain about the removal of the Supreme Court judges. Okay, how the member of the Supreme Court judges can be removed? They can be directly removed through the parliament only. Okay, to remove the Supreme Court judges, the bill can be introduced in either of the house, either Lok Sabha or Rajya Sabha. Let's suppose there is a Rajya Sabha member who want to remove any Supreme Court judge on the ground of post benefit, then the proposal can be started either of the house, either Lok Sabha and Rajya Sabha. To start the proposal, at least 100 member has to agree from the Lok Sabha and at least 50 members have to agree in the Rajya Sabha. The single member cannot initiate the removal bill of Supreme Court. At least 100 members from Lok Sabha and 50 members from Rajya Sabha has to agree. Let's suppose the bill is started through the Rajya Sabha, then 50 members would be agree. When the 50 members agree, then bill passed by the 2/3 majority. So to started the bill, at least 50 members assent is required, but to pass the bill, at least 2/3 members assent is required for both the houses, from Lok Sabha as well as Rajya Sabha. Clear? Then bill sent to the Rajya Sabha. Lok Sabha, after passing Rajya Sabha, Lok Sabha will also pass this bill with 2/3 majority. After passing the bill sent to the Speaker of Lok Sabha, and the Speaker of Lok Sabha create a 3 members committee. These 3 members submit their report to the President, and finally President will remove the judge of the Supreme Court on the basis of the report of 3 members. Clear? So this is the whole procedure of removal of the Supreme Court judges. The procedure is same for the High Court judges also. High Court judges can also be removed through the same as the Supreme Court judges removed. Next is, what are the jurisdiction of Supreme Court? There are 3 jurisdiction of Supreme Court under Article 131, under Article 132 and under Article 143. The first jurisdiction is original jurisdiction of Supreme Court. First, we have to understand original jurisdiction of Supreme Court. The second jurisdiction is appellate jurisdiction of Supreme Court. And the third jurisdiction is advisory jurisdiction of Supreme Court. What are the jurisdiction? Jurisdictions mean the power of the Supreme Court, basically. So in this class, we will also have to discuss the powers of the Supreme Court, in which field the Supreme Court can deal, basically. So what is original jurisdiction? Original jurisdictions means that Supreme Court can hear the dispute or can solve the cases related to the dispute between the government of India and one state or between 2 states. Let's suppose if there is any dispute between the Indian government or one or more states, then the case will be heard by Supreme Court. If any dispute between the Indian government and one of or more state government, or one side or one or more state government from another side, then these kinds of disputes are also solved by the Supreme Court. If there is a disputes between 2 states, then the cases will go to the Supreme Court only, and Supreme Court will hear these cases under original jurisdiction. The original jurisdiction deal with the disputes between the government of India and one or more states, or the government of India of any state of one side and another state of another side, or there is a disputes between 2 or more states, then this will also heard by the government of India by the Supreme Court of India under Article 131. Clear? The Supreme Court can hear the disputes under original jurisdiction. What is appellate jurisdiction? Appellate jurisdiction refers to the appeal. under Article 132 to under Article 134. What does it mean? It means, let's suppose, okay, we all know that if we are not satisfied with the decision of lower court, we can directly challenge the decision of lower court to the high court. And high court have to hear these courts, and this is known as appellate jurisdiction. Means if there is a case coming from appeal of high court, then Supreme Court has to hear the same case. So appellate jurisdiction give the power of Supreme Court to hearing the cases which came through the appeal. And the third jurisdiction is advisory jurisdiction. What does advisory jurisdictions mean? Advisory jurisdiction means if President of India wants any opinion or want any legal advice to the Supreme Court, then Supreme Court has to share his opinion with the President. Or we can say through advisory jurisdiction, President can take the legal advice from the Supreme Court of India. Clear? So these are the function of or jurisdiction of Supreme Court. Next is oath, tenure and resignation. The judge of the Supreme Court, upon assuming office, take an oath before the president of same person appointed by him. So basically the oath, they take oath before the president of India. The Supreme Court judges can hold the post until the age of 65 years. After the 65 years, they are not eligible to work in Supreme Court. So the tenure is maximum 65 years. They can submit their resign in written form to the president only. Or resignation became effective on acceptance by the president only. When president will accept the resignation bill, then only that will consider as, or that only the bill or the resignation will be affected. Clear? Next is acting judge and additional judge. What is acting judge and additional judge? As I told you, there are some judges and this is CJI post. Let's suppose due to some reason, if there is a CJI post is vacant, in which condition the post of CJI can be vacant? If let's suppose the CJI is removed by the parliament, if CJI is died during his term, if CJI submit his resignation to the president, if CJI is out of the country. In that condition, if the post of CJI is vacant, then a temporary judge will act as a CJI. As we cannot vacate the post of CJI, then for maximum 6 months, another judge will hold the post of CJI. Then this judge will known as the acting judge. The acting judge is explained under Article 127 of the Indian Constitution. So Article 127 of Indian Constitution explain about the acting judge. Acting judge are those judge who will act as a CJI in absence of CJI. So when the post of CJI is vacant due to any reason, a judge can be appointed through outside or from these judges. The other judge will act as a CJI of India for maximum 6 months. Like president, in absence of president, vice president will act as a president. Same in absence of CJI, acting judge act as a CJI under Article 127. So this acting judge is also appointed by the president. The qualification of acting judge must be equal to the judge of Supreme Court in India. And which article deal with the acting judge? Article 127 of Indian Constitution deal with the acting judge. Clear? So a retired judge can be appointed as an acting judge of the Supreme Court if the number of judges available is insufficient to hold and continue any session of the Supreme Court. Means if the existing judge are unable to hold any session of the Supreme Court in absence of CJI, then a retired judge can also be appointed as a acting judge of the Supreme Court. Clear? And the last is additional judge. Who is additional judge? Additional judge are those under Article 224. Let's suppose as a survey, approximately 80 lakh cases are pending in Indian Supreme Court, and there are total 33 judges to solve these cases. So, in case of emergency, some temporary judge can be appointed by the president to solve the cases for maximum 2 months. These 2 years, these judges are known as the additional judge. Additional judge means the judges who are temporarily appointed for maximum 2 years by the President of India or the Chief Justice of India. So the President can appoint additional judge for a temporary period. These judges are the temporary judge, not exceeding 2 years, but they can be reappointed in consulting with the Chief Justice of India and the Governor of the concerned state under Article 224. Clear? If they are appointed for any particular state, then president will consult with the governor of that state, and if they are appointed for the Supreme Court, then president will consult with the Chief Justice of India. Done. So let's quick revise the session. In this class, we discussed that there is 3 courts in India. First is Supreme Court, second is High Court, and third is the Subordinate Court of India. Supreme Court of India is under Article 124 to 147. The first Supreme Court was established under Regulating Act of India in 1773. But first Supreme Court, which is in Delhi, was established in January 28, 1950. Initially, there was 8 judges. At present, there are total 34 judges in Indian Supreme Court. The Parliament has power. Parliament can increase the number of judges time to time. For qualification or to become a Supreme Court judge, a person should be a citizen of India and at least 5 years for as a judge in any high court or 10 years as an advocate in any high court. How to appoint a Supreme Court judge? They can directly appointed by the president, but with the recommendation of collegium system. Collegium system is a team of 5 members which was established in 1993. The removal of the Supreme Court judges can be started any one of the house, either Lok Sabha or Rajya Sabha. But to remove a Supreme Court judge, at least 2/3 members are the bill was passed by the 2/3 majority of both the houses. Then finally, president will remove. Jurisdiction: Supreme Court have 3 jurisdiction: original, appellate, and advisory. In original jurisdiction under Article 131, he can solve the dispute between center and states and state and states. And appeal jurisdiction, he can basically hear the cases related to which was appealed from the high court or any lower court. And advisory jurisdiction, he can give the legal advice to the president. Oath are given by president, tenure for 65 years, and they can submit their resign to the president only. The acting judge under Article 127 and the additional judge under Article 224. Acting judge are those judge who was appointed in the place of the Chief Justice of India, and to solve the cases, the additional judge are appointed for maximum 2 years. Clear, Supreme Court? Now our next court is High Court under Article 214 to 222. We have discussed the Supreme Court is under Article 124 to 147 and the High Court is under Article 214 to 224. So the Article 214 to 224 of Indian Constitution deal with the High Court of India. Let's understand the history of the High Court of India. The first High Court was established during the time of British under High Court Act 1861. So during the time of British, a High Court Act was passed in 1861, and in this act there were 3 High Court who was first established, known as Calcutta High Court, Bombay High Court, and Madras High Court. And from out of these 3, the Calcutta High Court is the oldest High Court of India. So the High Court was established under the Indian High Court Act 1861. And in 1861 High Court Act, there were total 3 High Court in 1862, which was established, known as Calcutta High Court, known as Bombay High Court, and known as Madras High Court. Clear? Okay, subsequently, more high courts were established in different state. High court act as the principal civil court of original jurisdiction. So it is the principal civil court of original jurisdiction in India. Clear? Next, qualification for high court. First, you have to also understand Article 214. What does Article 214 says? Article 214 says that there should be a one high court for each state. I am repeating again, Article 214 says that there should be a one high court for each state in India. So it is required according to constitution previously that there should be a one high court for each state. As we all know, we have 28 states and 8 union territory, but there are total 25 high courts in India. So according to we are not working according to Article 214, as Article 214 says that there should be a one high court for each state. Laterly, under 7th Constitutional Amendment 1956, it was mandatory that Parliament can allow for one high court for two or more than two states. Previously, it was mentioned that there should be a one high court for each state, but under our 7th Amendment 1956, there were some changes done in Article 214, and it is allowed to the Parliament, or Parliament got power that Parliament can allow one high court for two or more than two states. So still we are working according to the constitution, but we made an amendment in Article 214. Next, what are the major qualifications to become a judge of any high court? To become a judge of any high court, the qualification is mentioned in Article 217, Clause 2. So, Clause 2 of Article 217 explain about the qualification of high court judges. To become the judge of any high court, a person must be a citizen of India. He must be a citizen of India. First qualification. Second, he must be an advocate of any high court or two or more than two high court for at least 10 years. So must be an advocate of high court or two or more such courts in succession for at least 10 years. As per Article 217, Clause 2 of Indian Constitution. He should possess eminent jurist quality and to be a distinguished legal practitioner in contact of president also. If there is a layak person in contact of president, then he can become the judge of any high court. Next is how we can appoint a judge of any high court. Dekho, the appointment of Supreme Court and High Court judges are same. They both are appointed through collegium system. As I told you, in Supreme Court, there is a collegium system, basically a team of 5 members. The team of 5 members included the Chief Justice of India and the Chief Justice of concerned High Court, or maybe a group of senior judge of Supreme Court, which is depend state to state. So a 5-member teams known as collegium system, which was introduced in 1993, is responsible to appoint the High Court judges. The team made a recommendation and submit his report to the president, and the president is the final authority who appoint the judge of the High Court. So they are appointed by the president only in one liner, but appointment is made based on the recommendation of the collegium system evolved through judicial interpretation. The collegium comprised the Chief Justice of India, the Chief Justice of the concerned High Court, and a group of senior judges of the Supreme Court of India. Clear? The next is how a judge of High Court can be removed. Same, the High Court judges can be removed through the same procedure, or through the Parliament of India or through the President of India. Whether the oath is given before the governor of that state, but the judge of High Court can be removed, same as the removal procedure of the Supreme Court judges. Okay, the removal of the High Court judges is mentioned in under Article 217 Clause 1. So, according to Article 217 Clause 1, the judge of the Supreme High Court can be removed by the President only. There is a complete procedure to remove the judge of any High Court. What is the procedure? The bill can be introduced either of the House, either Lok Sabha and Rajya Sabha. Let's suppose, okay, in what cases a judge of High Court can be removed? If he is using his post or he is basically doing benefit of his post, then he can be removed through the parliament only. Let's suppose there is a member in Lok Sabha who want to remove particular judge of High Court, then at least 100 members has to agree to start the bill of removal of High Court judges. If there are 100 members who are agree to the removal of the High Court judges, then the bill must be passed by the 2/3 majority. To introduce bill, the 100 members consent is required, and to pass the bill, 2/3 members consent is required. Then bill sent to the another house, Rajya Sabha, and in Rajya Sabha, the bill is also passed by the 2/3 majority. Once the bill is passed by both the houses, then bill sent to the Speaker of Lok Sabha. The Speaker of Lok Sabha create a 3 members committee including the CJI and 2 senior judges of the Supreme Court. These 3 members check on according to the law and submit their report to the President whether the person is found guilty or not, and at final the President can remove the judge of High Court. Clear? So a judge can be removed only by an order of the High Court. Removal can be initiated by motion in either house of the parliament. Means it can be started through either Lok Sabha or either Rajya Sabha. But a bill should be passed by not less than 2/3 of the member present and voting, and has been presented to the President in same session for such removal on the ground of misbehavior or incapacity under Article 217 Clause 1. Clear? Also, there was an inquiry committee. There is an inquiry committee who charged by a committee of judges. So this inquiry committee is established by the Speaker of Lok Sabha only. So this is the whole procedure to the removal of High Court judges. Here are some jurisdiction of the High Court judges. There, the first jurisdiction is original jurisdiction of High Court. Clear? Second is appellate jurisdiction of High Court, and third jurisdiction is supervision jurisdiction of the High Court. What is the original jurisdiction? The High Court have original jurisdiction of a certain type of cases within their territory jurisdiction. Okay, original jurisdiction means when the cases directly go to the High Court. Let's suppose if there is a case related to fundamental rights under Article 32, we have power, we can directly go to the High Court or Supreme Court. So if there is a case who is directly came to the High Court, then this is known as the original jurisdiction of High Court. So High Court have original jurisdiction related to certain type of cases. The second jurisdiction is known as the appellate jurisdiction of the High Court. Appellate jurisdiction mean appeal from the subordinate court within their territorial jurisdiction. If there is a case who is appealed by the appeal against the decision of subordinate court, then High Court has power. He can hear the case under appellate jurisdiction. Unlike Supreme Court has advisory jurisdiction in which Supreme Court can advise to the President, but High Court do not have any power to advise the President. So High Court have supervisory jurisdiction in which he can supervise the decision of lower cases through writs like habeas corpus, mandamus, certiorari, prohibition, and quo warranto. There are 5 writs under Article 226 the High Court can issue. In the next session, we will also discuss these 5 writs. You have to understand that in supervisory jurisdiction, the High Court can here or high court can supervise the decision of the lower court. Clear? So in original jurisdiction, the case can directly came to the high court. In appellate jurisdiction, if there is a case against the decision of Supreme Court, can be heard by the high court. And the third is supervisory jurisdiction. Clear? Okay. What are the oath, tenure, and resignation process of the judge of high court? Basically, the judge of high court take oath to before the governor of that state. The judge of Supreme Court take oath before the president, and they take oath before the judge of before the governor of that particular state. They can hold the post until the age of 62 years, or after retirement they are eligible to work with the Supreme Court of India. So they can hold the post till the age of 62 years. Okay, they can resign in the written form to the president or the governor of the concerned state. So they can submit their resignation to the president as well as the governor of the concerned state. And the resignation will be effective after the acceptance of the president or the governor only. And the last point is acting judge and additional judge of Supreme Court. Same as High Court. Under Article 224A, the acting judge can be appointed through the High Court, and under Article 224, an additional judge can be appointed by the president. What is acting judge? Let's see. This is the structure of the High Court. Here are some judges, and here are CJ, Chief Justice. Okay. Let's suppose if the Chief Justice of any High Court is removed or die, or the post of the Chief Justice is vacant, then a temporary judge can act as a Chief Justice of High Court, which is known as acting judge. So in absence of CJ, if the post of the CJ is vacant, then president or the High Court, basically the governor, can appoint a temporary judge for maximum 6 months, which is known as the acting judge under Article 224A. What are the additional judge? Additional judge are those judges which are appointed by the president when there is a requirement of judges to solve the case in the High Court under Article 224. So, acting judge, a retired judge can be appointed as the acting judge of the High Court if the number of judges available is insufficient to hold and continue any session of the High Court under Article 224A. So, any retired judge can be appointed as the acting judge of the High Court. Additional judge, the president can appoint additional judge for a temporary period not exceeding 2 years in consulting with the Chief Justice of the High Court under Article 224. Clear? Okay, so let's quick revise the session of High Court. High Court under Article 214 to 224. The first High Court was established under the High Court Act 1861, and there were 3 High Courts which was established, known as Calcutta, Bombay and Madras, and out of 3 High Courts, Calcutta is also the oldest High Court. Also, according to Article 214, there should be a 1 High Court for each state, but under Article 7, under Amendment 7, 1956, Parliament got power to basically appoint 1 High Court for 2 or more than 2 states. Qualification must be a advocate of any High Court for at least 10 years. They can directly appointed by the president, but under collegium system. Clear? And removal of the High Court judges can be removed by the president. So I hope you understand the session. Thank you.